need to formulate principles guidelines. Surely, the present MOAD can be renegotiated or another one will be drawn up to carry out the ancestral domain aspects of the Tripoli Agreement 2001, in another or in any form, which could contain similar or significantly drastic provisions. While the court notes the word of the Executive Secretary that the government is committed to securing an agreement that is both constitutional and equitable because that is the only way that long-lasting peace can be assured, it is minded to render a decision on the merits in the present petitions to formulate controlling principles to guide the bench, the bar, the public and, most especially, the government in negotiating with the MILF regarding ancestral domain. Respondents invite the court's attention to the separate opinion of then-Chief Justice Artemia Panganiban in San Lucas v. Res 104-104, in which he stated that the doctrine of capable of repetition yet evading review can override mootness, provided the party raising it in a proper case has been and/or continue to be prejudiced or damaged as a direct result of their issuance. They contend that the court must have jurisdiction over the subject matter for the doctrine to be invoked. The present petitions all contain prayers for prohibition over which this court exercises original jurisdiction. While GR number 183,893, City of Iligan v. GRP, is a petition for injunction and declaratory relief, the court will treat it as one for prohibition as it has far-reaching implications and raises questions that need to be resolved. 105. At all events, the court has jurisdiction over most if not the rest of the petitions. Indeed, the present petitions afford a proper venue for the court to again apply the doctrine immediately referred to as what it had done in a number of landmark cases. 106. There is a reasonable expectation that petitioners, particularly the provinces of North Cotabato, Zamboanga del Norte and Sultan Kudarat, the cities of Zamboanga, Iligan, and Isabela, and the municipality of Linnaman, will again be subjected to the same problem in the future as respondents' actions are capable of repetition, in another or any form. It is with respect to the prayers for mandamus that the petitions have become moot, respondents having, by compliance of August 7, 2008, provided this court and petitioners with official copies of the final draft of the MOAD and its annexes. 2. Interveners have been furnished, or have procured for themselves, copies of the MOAD. V. Substantive issues. As culled from the petitions and petitions in intervention, there are basically two substantive issues to be resolved, one relating to the manner in which the MOAD was negotiated and finalized, the other relating to its provisions, viz. 1. Did respondents violate constitutional and statutory provisions on public consultation and the right to information when they negotiated and later initialed the MOAD? 2. Do the contents of the MOAD violate the Constitution and the laws? On the first substantive issue, petitioners invoke their constitutional right to information on matters of public concern, as provided in Section 7, Article 3 on the Bill of Rights. Sec. 7. The right of the people to information on matters of public concern shall be recognized. Access to official records, and to documents, and papers pertaining to official acts, transactions, or decisions, as well as to government research data used as basis for policy development, shall be afforded the citizen, subject to such limitations as may be provided by law. 107. As early as 1948, in Subito v. Ozenta, 108, the court has recognized the statutory right to examine and inspect public records, a right which was eventually accorded constitutional status. The right of access to public documents, as enshrined in both the 1973 Constitution and the 1987 Constitution, has been recognized as a self-executory constitutional right. 109. In the 1976 case of Baldoza v. Honorable Judge Dimano, 110, the court ruled that access to public records is predicated on the right of the people to acquire information on matters of public concern since, undoubtedly, in a democracy, the public has a legitimate interest in matters of social and political significance. The incorporation of this right in the Constitution is a recognition of the fundamental role of free exchange of information in a democracy. There can be no realistic perception by the public of the nation's problems, nor a meaningful democratic decision-making if they are denied access to information of general interest. Information is needed to enable the members of society to cope with the exigencies of the times. As has been aptly observed, maintaining the flow of such information depends on protection for both its acquisition and its dissemination since, if either process is interrupted, the flow inevitably ceases. 111. In the same way that free discussion enables members of society to cope with the exigencies of their time, access to information of general interest aids the people in democratic decision-making by giving them a better perspective of the vital issues confronting the nation. 112, so that they may be able to criticize and participate in the affairs of the government in a responsible, reasonable and effective manner. It is by ensuring an unfettered and uninhibited exchange of ideas among a well-informed public that a government remains responsive to the changes desired by the people. 113. The MOAD is a matter of public concern. That the subject of the information sought in the present cases is a matter of public concern. 114 faces no serious challenge. In fact, respondents admit that the MOAD is indeed of public concern. 115 In previous cases, the court found that the regularity of real estate transactions entered in the Register of Deeds, 116, the need for adequate notice to the public of the various laws, 117, the civil service eligibility of a public employee, 118, the proper management of excess funds allegedly used to grant loans to public officials, 119, the recovery of the Marcoses' alleged ill-gotten wealth, 120, and the identity of party list nominees, 121, among others, are matters of public concern. Undoubtedly, the MOAD subject of the present cases is of public concern, involving as it does the sovereignty and territorial integrity of the state, which directly affects the lives of the public at large. Matters of public concern covered by the right to information include steps and negotiations leading to the consummation of the contract. In not distinguishing as to the executory nature or commercial character of agreements, the court has categorically ruled. The right to information contemplates inclusion of negotiations leading to the consummation of the transaction. Certainly, a consummated contract is not a requirement for the exercise of the right to information. Otherwise, the people can never exercise their right if no contract is consummated, and if one is consummated, it may be too late for the public to expose its defects. Requiring a consummated contract will keep the public in the dark until the contract, which may be grossly disadvantageous to the government or even illegal, becomes fait accompli. This negates the state policy of full transparency on matters of public concern, a situation which the framers of the Constitution could not have intended. Such a requirement will prevent the citizenry from participating in the public discussion of any proposed contract, effectively truncating a basic right enshrined in the Bill of Rights. We can allow neither an emasculation of a constitutional right, nor a retreat by the state of its avowed policy of full disclosure of all its transactions involving public interest. 122, emphasis and italics in the original. Intended as a splendid symmetry, 123, to the right to information under the Bill of Rights is the policy of public disclosure under Section 28, Article 2 of the Constitution reading. Sec. 28. Subject to reasonable conditions prescribed by law, the state adopts and implements a policy of full public disclosure of all its transactions involving public interest. 124. The policy of full public disclosure enunciated in above-quoted Section 28 complements the right of access to information on matters of public concern found in the Bill of Rights. The right to information guarantees the right of the people to demand information, while Section 28 recognizes the duty of officialdom to give information even if nobody demands. 125-125. The policy of public disclosure establishes a concrete ethical principle for the conduct of public affairs in a genuinely open democracy, with the people's right to know as the centerpiece. It is a mandate of the state to be accountable by following such policy. 126-126. These provisions are vital to the exercise of the freedom of expression and essential to hold public officials at all times accountable to the people. 127-127. Whether Section 28 is self-executory, the records of the deliberations of the Constitutional Commission so disclose. Mr. Suarez. And since this is not self-executory, this policy will not be enunciated or will not be in force and effect until after Congress shall have provided it. Mr. Opel. I expect it to influence the climate of public ethics immediately, but, of course, the implementing law will have to be enacted by Congress, Mr. Presiding Officer. 128-128. The following discourse, after Commissioner Hilario Davide Jr. sought clarification on the issue, is enlightening. Mr. Davide. I would like to get some clarifications on this. Mr. Presiding Officer, did I get the gentleman correctly as having said that this is not a self-executing provision? It would require legislation by Congress to implement? Mr. Opel. Yes. Originally, it was going to be self-executing, but I accepted an amendment from Commissioner Regalado, so that the safeguards on national interest are modified by the clause as may be provided by law. Mr. Davide. But as worded, does it not mean that this will immediately take effect and Congress may provide for reasonable safeguards on the sole ground national interest? Mr. Opel. Yes. I think so, Mr. Presiding Officer. I said earlier that it should immediately influence the climate of the conduct of public affairs, but, of course, Congress here may no longer pass a law revoking it, or if this is approved, revoking this principle, which is inconsistent with this policy. 129-129, emphasis supplied. Indubitably, the effectivity of the policy of public disclosure need not await the passing of a statute. As Congress cannot revoke this principle, it is merely directed to provide for reasonable safeguards. The complete and effective exercise of the right to information necessitates that its complementary provision on public disclosure derive the same self-executory nature. Since both provisions go hand in hand, it is absurd to say that the broader 130-130, right to information on matters of public concern is already enforceable while the correlative duty of the state to disclose its transactions involving public interest is not enforceable until there is an enabling law. Respondents cannot thus point to the absence of an implementing legislation as an excuse in not effecting such policy. An essential element of these freedoms is to keep open a continuing dialogue or process of communication between the government and the people. It is in the interest of the state that the channels for free political discussion be maintained to the end that the government may perceive and be responsive to the people's will. 131-131. Envisioned to be corollary to the twin rights to information and disclosure is the design for feedback mechanisms. Ms. Rosario Braid. Yes. And lastly, Mr. Presiding Officer, will the people be able to participate? Will the government provide feedback mechanisms so that the people can participate and can react where the existing media facilities are not able to provide full feedback mechanisms to the government? I suppose this will be part of the government implementing operational mechanisms. Mr. Opel. Yes. I think through their elected representatives, and that is how these courses take place. There is a message and a feedback, both ways. XXXX. Miss Rosario Braid. Mr. Presiding Officer, may I just make one last sentence? I think when we talk about the feedback network, we are not talking about public officials but also network of private business or community-based organizations that will be reacting. As a matter of fact, we will put more credence or credibility on the private network of volunteers and voluntary community-based organizations. So I do not think we are afraid that there will be another OMA in the making. 132-132, Emphasis supplied. The imperative of a public consultation, as a species of the right to information, is evident in the marching orders to respondents. The mechanics for the duty to disclose information and to conduct public consultation regarding the peace agenda and process is manifestly provided by EO No. 3. 133-133. The preambulatory clause of EO No. 3 declares that there is a need to further enhance the contribution of civil society to the comprehensive peace process by institutionalizing the people's participation. One of the three underlying principles of the comprehensive peace process is that it should be community-based, reflecting the sentiments, values and principles important to all Filipinos and shall be defined not by the government alone, nor by the different contending groups only, but by all Filipinos as one community. 134. Included as a component of the comprehensive peace process is consensus building and empowerment for peace, which includes continuing consultations on both national and local levels to build consensus for a peace agenda and process, and the mobilization and facilitation of people's participation in the peace process. 135. Clearly, EO No. 3 contemplates not just the conduct of a plebiscite to effectuate continuing consultations, contrary to respondents' position that plebiscite is more than sufficient consultation. 136. Further, EO No. 3 enumerates the functions and responsibilities of the PAP, one of which is to conduct regular dialogues with the National Peace Forum, NPF, and other peace partners to seek relevant information, comments, recommendations as well as to render appropriate and timely reports on the progress of the comprehensive peace process. 137. EO No. 3 mandates the establishment of the NPF to be the principal forum for the PAP to consult with and seek advice from the peace advocates, peace partners and concerned sectors of society on both national and local levels, on the implementation of the comprehensive peace process, as well as for government, civil society dialogue and consensus building on peace agenda and initiatives. 138. In fine, EO No. 3 establishes petitioners' right to be consulted on the peace agenda, as a corollary to the constitutional right to information and disclosure. PAP Esperon committed grave abuse of discretion. The PAP committed grave abuse of discretion when he failed to carry out the pertinent consultation. The furtive process by which the MOAD was designed and crafted runs contrary to and in excess of the legal authority, and amounts to a whimsical, capricious, oppressive, arbitrary and despotic exercise thereof. The court may not, of course, require the PAP to conduct the consultation in a particular way or manner. It may, however, require him to comply with the law and discharge the functions within the authority granted by the President. 139. Petitioners are not claiming a seat at the negotiating table, contrary to respondents' retort in justifying the denial of petitioners' right to be consulted. Respondents' stance manifests the manner by which they treat the salient provisions of EO No. 3 on people's participation. Such disregard of the express mandate of the President is not much different from superficial conduct toward token provisos that border on classic lip service. 140. It illustrates a gross evasion of positive duty and a virtual refusal to perform the duty enjoined. As for respondents' invocation of the doctrine of executive privilege, it is not tenable under the premises. The argument defies sound reason when contrasted with EO No. 3's explicit provisions on continuing consultation and dialogue on both national and local levels. The executive order even recognizes the exercise of the public's right even before the GRP makes its official recommendations or before the government proffers its definite propositions. 141. It bears emphasis that EO No. 3 seeks to elicit relevant advice, information, comments and recommendations from the people through dialogue. At all events, respondents effectively waived the defense of executive privilege in view of their unqualified disclosure of the official copies of the final draft of the MOAD. By unconditionally complying with the court's August 4, 2008 resolution, without a prayer for the document's disclosure in camera, or without a manifestation that it was complying therewith ex abundant ad cautelam. Petitioner's assertion that the Local Government Code, LGC, of 1991 declares it a state policy to require all national agencies and offices to conduct periodic consultations with appropriate local government units, non-governmental and people's organizations, and other concerned sectors of the community before any project or program is implemented in their respective jurisdictions, 142-142, is well taken. The LGC chapter on intergovernmental relations puts flesh into this avowed policy. Prior consultations required. No project or program shall be implemented by government authorities unless the consultations mentioned in sections 2, c, and 26 hereof are complied with, and prior approval of the Sanguinian concerned is obtained, provided that occupants in areas where such projects are to be implemented shall not be evicted unless appropriate relocation sites have been provided, in accordance with the provisions of the Constitution. 143-143, italics and underscoring supplied. In Lena Jr. v. Honorable Pano, 144-144. The court held that the above stated policy and above quoted provision of the LGU apply only to national programs or projects which are to be implemented in a particular local community. Among the programs and projects covered are those that are critical to the environment and human ecology, including those that may call for the eviction of a particular group of people residing in the locality where these will be implemented. 145-145. The MOAD is one peculiar program that unequivocally and unilaterally vests ownership of a vast territory to the Bangsamoro people, 146-146, which could pervasively and drastically result to the diaspora or displacement of a great number of inhabitants from their total environment. With respect to the indigenous cultural communities, indigenous peoples, ICC's IPs, whose interests are represented herein by Petitioner Lopez and are adversely affected by the MOAD, the ICC's IPs have, under the APRA, the right to participate fully at all levels of decision-making in matters which may affect their rights, lives and destinies. 147-147, the MOAD, an instrument recognizing ancestral domain, failed to justify its non-compliance with the clear-cut mechanisms ordained in said Act. 148-148, which entails, among other things, the observance of the free and prior informed consent of the ICC's IPs. Notably, the APRA does not grant the executive department or any government agency the power to delineate and recognize an ancestral domain claim by mere agreement or compromise. The recognition of the ancestral domain is the raison d'etre of the MOAD, without which all other stipulations or consensus points necessarily must fail. In proceeding to make a sweeping declaration on ancestral domain, without complying with the APRA, which is cited as one of the Torah of the MOAD, respondents clearly transcended the boundaries of their authority. As it seems, even the heart of the MOAD is still subject to necessary changes to the legal framework. While paragraph 7 on governance suspends the effectivity of all provisions requiring changes to the legal framework, such clause is itself invalid, as will be discussed in the following section. Indeed, ours is an open society, with all the acts of the government subject to public scrutiny and available always to public cognizance. This has to be so if the country is to remain democratic, with sovereignty residing in the people and all government authority emanating from them. 149-149. On the second substantive issue. With regard to the provisions of the MOAD, there can be no question that they cannot all be accommodated under the present Constitution and laws. Respondents have admitted as much in the oral arguments before this court, and the MOAD itself recognizes the need to amend the existing legal framework to render effective at least some of its provisions. Respondents, nonetheless, counter that the MOAD is free of any legal infirmity because any provisions therein which are inconsistent with the present legal framework will not be effective until the necessary changes to that framework are made. The validity of this argument will be considered later. For now, the court shall pass upon how the MOAD is inconsistent with the Constitution and laws as presently worded. In general, the objections against the MOAD center on the extent of the powers conceded therein to the BJE. petitioners assert that the powers granted to the BJE exceed those granted to any local government under present laws, and even go beyond those of the present arm. Before assessing some of the specific powers that would have been vested in the BJE, however, it would be useful to turn first to a general idea that serves as a unifying link to the different provisions of the MOAD, namely, the international law concept of association. Significantly, the MOAD explicitly alludes to this concept, indicating that the parties actually framed its provisions with it in mind. Association is referred to in paragraph 3 on territory, paragraph 11 on resources, and paragraph 4 on governance. It is in the last mentioned provision, however, that the MOAD most clearly uses it to describe the envisioned relationship between the BJE and the central government. 4. The relationship between the central government and the Bangsamoro juridical entity shall be associative, characterized by shared authority and responsibility with a structure of governance based on executive, legislative, judicial and administrative institutions with defined powers and functions in the Comprehensive Compact. A period of transition shall be established in a Comprehensive Peace Compact specifying the relationship between the central government and the BJE. Emphasis and underscoring supplied. The nature of the associative relationship may have been intended to be defined more precisely in the still-to-be-forged Comprehensive Compact. Nonetheless, given that there is a concept of association in international law, and the MOAD, by its inclusion of international law instruments in its TOR, placed itself in an international legal context, that concept of association may be brought to bear in understanding the use of the term associative in the MOAD. Kner and Reisman state that an association is formed when two states of unequal power voluntarily establish durable links. In the basic model, one state, the associate, delegates certain responsibilities to the other, the principal, while maintaining its international status as a state. Free associations represent a middle ground between integration and independence. XXX 150-150, emphasis and underscoring supplied. For purposes of illustration, the Republic of the Marshall Islands and the Federated States of Micronesia, FSM, formerly part of the U.S.-administered Trust Territory of the Pacific Islands, 151-151, are associated states of the U.S. pursuant to a compact of free association. The currency in these countries is the U.S. dollar, indicating their very close ties with the U.S., yet they issue their own travel documents, which is a mark of their statehood. Their international legal status as states was confirmed by the UN Security Council and by their admission to UN membership. According to their compacts of free association, the Marshall Islands and the FSM generally have the capacity to conduct foreign affairs in their own name and right, such capacity extending to matters such as the law of the sea, marine resources, trade, banking, postal, civil aviation, and cultural relations. The U.S. government, when conducting its foreign affairs, is obligated to consult with the governments of the Marshall Islands or the FSM on matters which it, U.S. government, regards as relating to or affecting either government. In the event of attacks or threats against the Marshall Islands or the FSM, the U.S. government has the authority and obligation to defend them as if they were part of U.S. territory. The U.S. government, moreover, has the option of establishing and using military areas and facilities within these associated states and has the right to bar the military personnel of any third country from having access to these territories for military purposes. It bears noting that in U.S. constitutional and international practice, free association is understood as an international association between sovereigns. The Compact of Free Association is a treaty which is subordinate to the associated nation's national constitution, and each party may terminate the association consistent with the right of independence. It has been said that, with the admission of the U.S. associated states to the UN in 1990, the UN recognized that the American model of free association is actually based on an underlying status of independence. 152-152. In international practice, the associated state arrangement has usually been used as a transitional device of former colonies on their way to full independence. Examples of states that have passed through the status of associated states as transitional phase are Antigua, St. Kitts Nevis Anguilla, Dominica, St. Lucia, St. Vincent, and Grenada. All have since become independent states. 153. Back to the MOAD, it contains many provisions which are consistent with the international legal concept of association, specifically the following: the BJE's capacity to enter into economic and trade relations with foreign countries, the commitment of the central government to ensure the BJE's participation in meetings and events in the ASEAN and the specialized UN agencies, and the continuing responsibility of the central government over external defense. Moreover, the BJE's right to participate in Philippine official missions bearing on negotiation of border agreements, environmental protection, and sharing of revenues pertaining to the bodies of water adjacent to or between the islands forming part of the ancestral domain, resembles the right of the governments of FSM and the Marshall Islands to be consulted by the U.S. government on any foreign affairs matter affecting them. These provisions of the MO indicate, among other things, that the parties aimed to vest in the BJE the status of an associated state or, at any rate, a status closely approximating it. The concept of association is not recognized under the present constitution. No province, city, or municipality, not even the arm, is recognized under our laws as having an associative relationship with the national government. Indeed, the concept implies powers that go beyond anything ever granted by the Constitution to any local or regional government. It also implies the recognition of the associated entity as a state. The Constitution, however, does not contemplate any state in this jurisdiction other than the Philippine state, much less does it provide for a transitory status that aims to prepare any part of Philippine territory for independence. Even the mere concept animating many of the MOAD's provisions, therefore, already requires for its validity the amendment of constitutional provisions, specifically the following provisions of Article X. Section 1. The territorial and political subdivisions of the Republic of the Philippines are the provinces, cities, municipalities, and barangays. There shall be autonomous regions in Muslim Mindanao and the Cordilleras as hereinafter provided. Section 15. There shall be created autonomous regions in Muslim Mindanao and in the Cordilleras consisting of provinces, cities, municipalities, and geographical areas sharing common and distinctive historical and cultural heritage, economic and social structures, and other relevant characteristics within the framework of this Constitution and the national sovereignty as well as territorial integrity of the Republic of the Philippines. The BJE is a far more powerful entity than the autonomous region recognized in the Constitution. It is not merely an expanded version of the arm, the status of its relationship with the national government being fundamentally different from that of the arm. Indeed, BJE is a state in all but name as it meets the criteria of a state laid down in the Montevideo Convention, 154-154, namely, a permanent population, a defined territory, a government, and a capacity to enter into relations with other states. Even assuming arguendo that the MOAD would not necessarily sever any portion of Philippine territory, the spirit animating it, which has betrayed itself by its use of the concept of association, runs counter to the national sovereignty and territorial integrity of the Republic. The defining concept underlying the relationship between the national government and the BJE being itself contrary to the present Constitution, it is not surprising that many of the specific provisions of the MOAD on the formation and powers of the BJE are in conflict with the Constitution and the laws. Article X, Section 18 of the Constitution provides that, the creation of the autonomous region shall be effective when approved by a majority of the votes cast by the constituent units in a plebiscite called for the purpose, provided that only provinces, cities, and geographic areas voting favorably in such plebiscite shall be included in the autonomous region. Emphasis supplied. As reflected above, the BJE is more of a state than an autonomous region. But even assuming that it is covered by the term autonomous region in the constitutional provision just quoted, the MOAD would still be in conflict with it. Under paragraph 2c on territory in relation to 2d and 2e, the present geographic area of the arm and, in addition, The municipalities of Lanao del Norte which voted for inclusion in the ARM during the 2001 plebiscite, Baloy, Munay, Nunungan, Panchar, Tigaloan and Tangkal, are automatically part of the BJE without need of another plebiscite, in contrast to the areas under categories A and B mentioned earlier in the overview. That the present components of the ARM and the above-mentioned municipalities voted for inclusion therein in 2001, however, does not render another plebiscite unnecessary under the Constitution, precisely because what these areas voted for then was their inclusion in the ARM, not the BJE. The MOAD, moreover, would not comply with Article X, Section 20 of the Constitution, since that provision defines the powers of autonomous regions as follows. Section 20. Within its territorial jurisdiction and subject to the provisions of this Constitution and national laws, the Organic Act of Autonomous Regions shall provide for legislative powers over 1. Administrative organization. 2. Creation of sources of revenues. 3. Ancestral domain and natural resources. 4. Personal, family, and property relations. 5. Regional urban and rural planning development. 6. Economic, social, and tourism development. 7. Educational policies. 8. Preservation and development of the cultural heritage, and 9. Such other matters as may be authorized by law for the promotion of the general welfare of the people of the region. Underscoring supplied. Again, on the premise that the BJE may be regarded as an autonomous region, the MOAD would require an amendment that would expand the above-quoted provision. The mere passage of new legislation pursuant to subparagraph number 9 of said constitutional provision would not suffice, since any new law that might vest in the BJE the powers found in the MOAD must, itself, comply with other provisions of the Constitution. It would not do, for instance, to merely pass legislation vesting the BJE with treaty-making power in order to accommodate paragraph 4 of the Strand on Resources, which states, the BJE is free to enter into any economic cooperation and trade relations with foreign countries, provided, however, that such relationships and understandings do not include aggression against the government of the Republic of the Philippines XXX. Under our constitutional system, it is only the President who has that power. Pimentel v. Executive Secretary 155 instructs. In our system of government, the President, being the head of state, is regarded as the sole organ and authority in external relations and is the country's sole representative with foreign nations. As the chief architect of foreign policy, the President acts as the country's mouthpiece with respect to international affairs. Hence, the President is vested with the authority to deal with foreign states and governments, extend or withhold recognition, maintain diplomatic relations, enter into treaties, and otherwise transact the business of foreign relations. In the realm of treaty-making, the President has the sole authority to negotiate with other states. Emphasis and underscoring supplied. Article 2, Section 22 of the Constitution must also be amended if the scheme envisioned in the MOAD is to be effected. That constitutional provision states, the state recognizes and promotes the rights of indigenous cultural communities within the framework of national unity and development. Underscoring supplied, an associative arrangement does not uphold national unity. While there may be a semblance of unity because of the associative ties between the BJE and the national government, the act of placing a portion of Philippine territory in a status which, in international practice, has generally been a preparation for independence, is certainly not conducive to national unity. Besides being irreconcilable with the Constitution, the MOAD is also inconsistent with prevailing statutory law, among which are RA number 9054-156-156, or the Organic Act of the ARM, and the IPRA. 157. Article X, Section 3 of the Organic Act of the ARM is a bar to the adoption of the definition of Bangsamoro people used in the MOAD. Paragraph 1 on concepts and principles states. 1. It is the birthright of all Moros and all indigenous peoples of Mindanao to identify themselves and be accepted as Bangsamoros. The Bangsamoro people refers to those who are natives or original inhabitants of Mindanao and its adjacent islands including Palawan and the Sulu archipelago at the time of conquest or colonization of its descendants, whether mixed or of full blood. Spouses and their descendants are classified as Bangsamoro. The freedom of choice of the indigenous people shall be respected. Emphasis and underscoring supplied. This use of the term Bangsamoro sharply contrasts with that found in the Article X, Section 3 of the Organic Act, which, rather than lumping together the identities of the Bangsamoro and other indigenous peoples living in Mindanao, clearly distinguishes between Bangsamoro people and tribal peoples, as follows. As used in this Organic Act, the phrase indigenous cultural community refers to Filipino citizens residing in the autonomous region who are a. Tribal peoples. These are citizens whose social, cultural and economic conditions distinguish them from other sectors of the national community, and b. Bangsamoro people. These are citizens who are believers in Islam and who have retained some or all of their own social, economic, cultural, and political institutions. Respecting the IPRA, it lays down the prevailing procedure for the delineation and recognition of ancestral domains. The MOAD's manner of delineating the ancestral domain of the Bangsamoro people is a clear departure from that procedure. By paragraph 1 of territory, the parties simply agree that, subject to the delimitations in the agreed schedules, the Bangsamoro homeland and historic territory refer to the landmass as well as the maritime, terrestrial, fluvial and alluvial domains, and the aerial domain, the atmospheric space above it, embracing the Mindanao-Sulu-Palawan geographic region. Chapter 8 of the IPRA, on the other hand, lays down a detailed procedure, as illustrated in the following provisions thereof. Section 52. Delineation Process. The identification and delineation of ancestral domains shall be done in accordance with the following procedures. XXXX. B. Petition for delineation. The process of delineating a specific perimeter may be initiated by the NSIP with the consent of the ICC/IP concerned, or through a petition for delineation filed with the NSIP, by a majority of the members of the ICC's IPs. C. Delineation proper. The official delineation of ancestral domain boundaries including census of all community members therein, shall be immediately undertaken by the Ancestral Domains Office upon filing of the application by the ICC's IPs concerned. Delineation will be done in coordination with the community concerned and shall at all times include genuine involvement and participation by the members of the communities concerned. D. Proof required. Proof of ancestral domain claims shall include the testimony of elders or community under oath, and other documents directly or indirectly attesting to the possession or occupation of the area since time immemorial by such ICC's IPs and the concept of owners, which shall be any one of the following authentic documents. 1. Written accounts of the ICC's IPs customs and traditions. 2. Written accounts of the ICC's IPs political structure and institution. 3. Pictures showing long-term occupations such as those of old improvements, burial grounds, sacred places and old villages. 4. Historical accounts, including pacts and agreements concerning boundaries entered into by the ICC's IPs concerned with other ICC's IPs. 5. Survey plans and sketch maps. 6. Anthropological data. 7. Genealogical surveys. 8. Pictures and descriptive histories of traditional communal forests and hunting grounds. 9. Pictures and descriptive histories of traditional landmarks such as mountains, rivers, creeks, ridges, hills, terraces and the like, and 10. Write-ups of names and places derived from the native dialect of the community. E. Preparation of maps. On the basis of such investigation and the findings of fact based thereon, the Ancestral Domains Office of the NSIP shall prepare a perimeter map, complete with technical descriptions, and a description of the natural features and landmarks embraced therein. F. Report of investigation and other documents. A complete copy of the preliminary census and a report of investigation, shall be prepared by the Ancestral Domains Office of the NSIP. G. Notice and publication. A copy of each document, including a translation in the native language of the ICC's IPs concerned, shall be posted in a prominent place therein for at least 15 days. A copy of the document shall also be posted at the local, provincial and regional offices of the NCIP, and shall be published in a newspaper of general circulation once a week for two consecutive weeks to allow other claimants to file opposition thereto within 15 days from date of such publication, provided that in areas where no such newspaper exists, broadcasting in a radio station will be a valid substitute, provided, further, that mere posting shall be deemed sufficient if both newspaper and radio station are not available. H. Endorsement to NCIP. Within 15 days from publication, and of the inspection process, the Ancestral Domains Office shall prepare a report to the NCIP endorsing a favorable action upon a claim that is deemed to have sufficient proof. However, if the proof is deemed insufficient, the Ancestral Domains Office shall require the submission of additional evidence, provided that the Ancestral Domains Office shall reject any claim that is deemed patently false or fraudulent after inspection and verification, provided, further, that in case of rejection, the Ancestral Domains Office shall give the applicant due notice, copy furnished all concerned, containing the grounds for denial. The denial shall be appealable to the NCIP, provided, furthermore, that in cases where there are conflicting claims among ICC's IPs on the boundaries of ancestral domain claims, the Ancestral Domains Office shall cause the contending parties to meet and assist them in coming up with a preliminary resolution of the conflict, without prejudice to its full adjudication according to the section below. XXXX. To remove all doubts about the irreconcilability of the MOAD with the present legal system, a discussion of not only the Constitution and domestic statutes, but also of international law is in order. 4. Article 2, Section 2 of the Constitution states that the Philippines adopts the generally accepted principles of international law as part of the law of the land. Applying this provision of the Constitution, the Court, in Mijoff v. Director of Prisons, 158-158, held that the Universal Declaration of Human Rights is part of the law of the land, on account of which it ordered the release on bail of a detained alien of Russian descent whose deportation order had not been executed even after 2 years. Similarly, the Court in Agustin v. Edu 159-159, applied the aforesaid constitutional provision to the 1968 Vienna Convention on Road Signs and Signals. International law has long recognized the right to self-determination of peoples, understood not merely as the entire population of a state but also a portion thereof. In considering the question of whether the people of Quebec had a right to unilaterally secede from Canada, the Canadian Supreme Court in reference Recession of Quebec 160-160, had occasion to acknowledge that the right of a people to self-determination is now so widely recognized in international conventions that the principle has acquired a status beyond convention and is considered a general principle of international law. Among the conventions referred to are the International Covenant on Civil and Political Rights 161-161, and the International Covenant on Economic, Social and Cultural Rights 162-162. Which state, in Article 1 of both covenants, that all peoples, by virtue of the right of self-determination, freely determine their political status and freely pursue their economic, social, and cultural development. The people's right to self-determination should not, however, be understood as extending to a unilateral right of secession. A distinction should be made between the right of internal and external self-determination. Reference Recession of Quebec is again instructive. 2. Scope of the right to self-determination. 126. The recognized sources of international law establish that the right to self-determination of a people is normally fulfilled through internal self-determination, a people's pursuit of its political, economic, social and cultural development within the framework of an existing state. A right to external self-determination, which in this case potentially takes the form of the assertion of a right to unilateral secession, arises in only the most extreme of cases and, even then, under carefully defined circumstances. XXX. External self-determination can be defined as in the following statement from the Declaration on Friendly Relations, Supra, as the establishment of a sovereign and independent state, the free association or integration with an independent state or the emergence into any other political status freely determined by a people constitute modes of implementing the right of self-determination by that people. Emphasis added. 127. The international law principle of self-determination has evolved within a framework of respect for the territorial integrity of existing states. The various international documents that support the existence of a people's right to self-determination also contain parallel statements supportive of the conclusion that the exercise of such a right must be sufficiently limited to prevent threats to an existing state's territorial integrity or the stability of relations between sovereign states. XXXX, emphasis, italics and underscoring supplied. The Canadian court went on to discuss the exceptional cases in which the right to external self-determination can arise, namely, where a people is under colonial rule, is subject to foreign domination or exploitation outside a colonial context, and, less definitely but asserted by a number of commentators, is blocked from the meaningful exercise of its right to internal self-determination. The court ultimately held that the population of Quebec had no right to secession, as the same is not under colonial rule or foreign domination, nor is it being deprived of the freedom to make political choices and pursue economic, social and cultural development, citing that Quebec is equitably represented in legislative, executive and judicial institutions within Canada, even occupying prominent positions therein. The exceptional nature of the right of secession is further exemplified in the report of the International Committee of Jurists on the legal aspects of the Åland Islands question. 163-163, there, Sweden presented to the Council of the League of Nations the question of whether the inhabitants of the Åland Islands should be authorized to determine by plebiscite if the archipelago should remain under Finnish sovereignty or be incorporated in the Kingdom of Sweden. The Council, before resolving the question, appointed an international committee composed of 3 jurists to submit an opinion on the preliminary issue of whether the dispute should, based on international law, be entirely left to the domestic jurisdiction of Finland. The committee stated the rule as follows. XXX, in the absence of express provisions in international treaties, the right of disposing of national territory is essentially an attribute of the sovereignty of every state. Positive international law does not recognize the right of national groups, as such, to separate themselves from the state of which they form part by the simple expression of a wish, any more than it recognizes the right of other states to claim such a separation. Generally speaking, the grant or refusal of the right to a portion of its population of determining its own political fate by plebiscite or by some other method, is, exclusively, an attribute of the sovereignty of every state which is definitively constituted. A dispute between 2 states concerning such a question, under normal conditions therefore, bears upon a question which international law leaves entirely to the domestic jurisdiction of one of the states concerned. Any other solution would amount to an infringement of sovereign rights of a state and would involve the risk of creating difficulties and a lack of stability which would not only be contrary to the very idea embodied in term state, but would also endanger the interests of the international community. If this right is not possessed by a large or small section of a nation, neither can it be held by the state to which the national group wishes to be attached, nor by any other state.